There is a new filing in the Disney case. This is the federal case, the DeSantis versus Disney case in federal court, one of two cases pending against Disney regarding their Florida property. That is the Walt Disney World Resort in Florida and the special district in Florida, which is really at the heart of all of this legal battle business in Florida. And this filing exposes a huge media bias and actually proves exactly what we've been saying all along on this channel and on other great channels that you follow. So we're going to get into it today about this new filing, what it is, what it means, why it's wrong, and why this is really being put out now. Of course, guys, I am Andrew Esquire, a Florida attorney, a specialist in special district law, someone who did that for 10 years in Central Florida, and who knows a lot about Reedy Creek, a lot about Disney, and a lot about what's going on in Central Florida. So let's hop right into it. So what is the court filing that we have today? Well, we actually have a court filing called an amicus brief. And this is very, very specific, and I'll explain this to you guys here today. So an amicus brief is something called a friend of the court brief. So amicus curiae means friend of the court. I know I'm butchering that. I'm not a Latin specialist. I'm just a simple Florida lawyer. Now, this amicus brief is filed by the Reporters Committee for the Freedom of the Press. Now, this is a group made up of several mainstream media, and let me stress this very carefully, mainstream media outlets. CNN, NPR, Time Magazine, LA, Times. These are major periodicals, newspapers, mainstream media, all of it legacy media. This is no alternative media. There's no conservative media in here. Certainly no Blaze, no Breitbart, nothing else. These are the very much establishment organizations, and especially the left-leaning and highly biased politically organizations. Things like Politico, for example, that are included in this coalition. So this coalition does have an extreme bias when it comes to the political spectrum, which I think plays in here, particularly as one of the parties is Mr. Ronald DeSantis, who happens to be running for a certain Republican presidency, and certainly has been a strong Republican his entire career, political career. So that being said, these reporters are filing a friend of the court brief. Now, why do they have to file a friend of the court brief? That's because they don't have actual standing in the federal case. They're actually not damaged by this. This case in no way will affect journalists. It has no impact on journalists directly, no impact at all. In fact, the only thing they're trying to say in this entire brief, they concocted out 40 pages, which they spent time, money, and effort, hard-earned donation money to their foundation, or rather given to them by the mainstream media, to come up with 40 pages pretty much crying and whining on how the First Amendment is so important. Now, listen, I love the First Amendment, but I'm all for calling balls and strikes. I'm all for calling it appropriately when the First Amendment applies and when it doesn't apply. And anybody who's been listening to this channel does know that in this case, the First Amendment does not apply to the federal case. Here's why. It doesn't apply for three specific reasons, and this brief really doesn't hit home for three specific reasons, despite talking a lot about the First Amendment. The first reason why it doesn't hit home is, well, there actually was never any damage to Disney's speech directly. Disney was never told they can't say what they want. In fact, Disney is free to say what they want. They've continued to say what they want. Their representatives have said what they want. Their CEO says what he wants. And well, we see this play out in media. In fact, Bob Iger just said what he wanted about the strikers over in California, and you see the backlash against that. It's kind of the woke, eat woke mentality. But that being said, Disney was never punished. The only thing that went away was RCID. And it really didn't go away. It was transformed into the CFTOD, the Central Florida Tourism Oversight District. The government, this is a government, a special district that is supposed to be, in fact, it's required to be separate from Disney. It's required to be a public entity that is run ostensibly by residents or by elected representatives, which represent the landowners. But when they're acting in that capacity, the capacity as representative, well, they're not representing the company and they can't represent the company any more than a elected representative to your city or county can represent the specific company that they work for. Let's say somebody worked for PepsiCo on one city's board and the rival city was Coca-Cola, right? And they had a Coca-Cola representative and they, had some sort of battle going back and forth. Okay, yes, PepsiCo and Coca-Cola, yes, they have a rivalry, they have a battle going back and forth, but they can't be allowed to capture that entire government. If an entire government is working for a specific corporation, well, it's not a government anymore. It's just another arm of a corporation. It's an alter ego, much like a corporation can be an alter ego of a person. So in that same way, Disney and RCID were always separate and were always separate things. In these districts, what they really are is a delegation of the state's power. So the state gives these entities, whether they're cities, counties, or special districts, its own power. And the state, at its own will, can take that away because state power is derived by the people from the people. And those people, through their representatives to the state legislature, can pull that at any time, can pull their sovereignty from a city, county, or elsewise. In fact, many states have decided, hey, we don't need counties, so we're just going to really get rid of counties or turn them into administrative only or geographic only, only for drawing a cute little boundary around an area. But otherwise, they really don't do anything. And that's a state's right. And this whole confusion between Reedy Creek and Disney, this is key to the argument of the mainstream media, in this case, these journalists filing this amicus curiae, and Disney. They've been doing this entire time. They've been obscuring the lines between Disney and RCID, now the CFTOD, which is extremely problematic given that if they are indeed the same thing, well, then they've committed bond fraud, securities fraud, made material contractual misrepresentations, and a whole host of other things. So just throwing that out there that these two things are separate. The second thing is that none of this case law they use, and I've actually read through all 40 pages of this. I read every single case they cited. First of all, none of the cases are really Florida specific, but second of all, none of them apply to governments being created or destroyed. There is not a single case in existence that deals with a special district being created or destroyed by a state. Doesn't exist. This doesn't exist. The case law that they use, that they rely upon for a proof of First Amendment violation, is, for example, an employee losing their job because of, let's say, their opinion on the Vietnam War or on President Nixon or on a mayoral candidate saying, I don't like that candidate for mayor, or I don't like Nixon, or I don't like the Vietnam War, and they get fired. That's not the same thing as a state deciding through a legislative process, through its literal legislative body, that, yeah, we're going to withdraw our power. We're going to withdraw our state power. It's completely different than anything they're arguing here above. So the case law that they cite here is really irrelevant. And the last thing, and the most important thing that they really fail on in this argument, in this amicus curiae, is all of this talks about the First Amendment, which, mind you, if we go over to the Disney complaint, and this is the actual Disney complaint, the thing that was filed in court on behalf of Disney, if you look at the actual counts, there's a list of the causes of action. There's 5 causes of action. 3 of them have nothing to do with the First Amendment violations. In fact, the strongest, i.e. the first 3, have nothing to do with the First Amendment. Only the last 2 claims have anything to do with the First Amendment. And of those last 2 claims, the 4th and 5th causes of action, one of those is entirely based on the state contracts, which are going to be invalidated. But we'll get back to that in a second. So you've only got 2 out of the 5 that are relating to the First Amendment. It doesn't really address the others. And the most important thing is nothing in here really talks about standing and why Disney has standing to bring this claim. That's one of the major issues in the motion to dismiss. And this amicus curiae is really intended to support Disney and oppose the motion to dismiss. If you actually look at what it's seeking to actually keep this in federal court and to deny a motion to dismiss. You can see here the motions to dismiss should be denied. Well, they just want to do that because they're just go on and on about the First Amendment being important, but that doesn't address standing, and that doesn't address also priority and the state court having priority. Now that the state court has decided, no, this is state law, we're going to rule on this, the federal court is actually bound. They are bound to dismiss this case or stay this case. So at least in part to grant the motions to dismiss, one of the motions to dismiss, or an alternative, grant a stay. So they actually need to do that now. But nothing in this amicus curiae, nothing in this brief addresses why we should keep this in federal court. Why should this just not all go to state court and be hashed out in state court? There's no reason why it cannot be, other than Disney wants to delay, and they also want a forum shop for the best judge possible for the mouse. And in fact, I would argue that the real issue here, guys, the real thing that's going on here is, of course, once again, the media is covering for Disney. Disney just took a massive loss in their state case. So remember, there's two cases going on right now. They took a massive loss in their state case by being denied a motion to dismiss. Because the case will go on there, they know the law is very clear. The federal case must be stayed, or at least must be stayed in part. At minimum, the first 4 counts need to be stayed. Maybe you could go ahead on the 5th count, but likely that one, once again, the weakest one, the one that's most likely to be thrown out, probably don't want to do that. More likely, you want to dismiss the federal case and have it refiled after the conclusion of the state case. That would actually be the best way to resolve this. And Disney knows this, their lawyers know this, and the media knows this. And the media time and time again has shilled for Disney, has come out and simped for Disney. And you've seen this where they bend the knee. Why do they do that? Because Disney promises them ad bucks, because Disney works with them, partners with them. Disney has always given them access to special information about Disney. And in return, Disney asks for certain favors. Now, this is just one of those favors in the form of a amicus curiae, a friend of the court brief. So ultimately, I think the arguments in this amicus curiae are absolutely weak. I think they're absolutely the worst. And I think they're meant as a distraction, because Disney time and time again employs the tactic of putting out a distraction anytime there's bad news. So every single time there's some bad news about Disney, they cover it up with something else. They cover it up with some other news. And this is one where, hey, this guy, legal mindset, I don't let it slide. I call it like I see it, and I call it out immediately. Let's stay on the ball here, and you know I'm going to stay on top of this case and all things related to Disney legal. If you like this, please make sure to like, smash the like, so make sure you subscribe, notifications on. Sometimes we do talk about very important topics, and sometimes they get a little spicy, and we might get shadow banned or censored. So make sure you share this out, because, hey, I see sometimes my videos, they're not getting shared out properly. The algorithm's not going out. They're not getting notifications. So make sure you do that, and you'll really help out me and this channel. Until next time, guys, take care. Peace.